everyone. I am Meg Leta Jones. Up until recently, I was Meg Leta Ambrose. I have become much more anonymous with my new married name. I'm an assistant professor at Georgetown University in the Communication, Culture, and Technology department. I'm going to be talking about the right to be forgotten today. The right to be forgotten is about legally addressing lingering information about individuals that threatens to shackle them to their past through exposure to opaque data processing and online judgment. And what we see by looking at a few comparative cases is that any right to be forgotten is going to have to account for an extraordinary number of circumstances, and that extremes have resulted due to, of course, some distinct legal cultures, but also some conceptual muddles and some technical framing problems. So I'm going to run through a little comparative case analysis and then talk about what the right to be forgotten could apply to, and then go into a little bit about the ephemerality of digital content. So the right to be forgotten is tasked with addressing digital information, which is just everything. The internet is full of everything. I lasted 2 minutes sitting down. Over here, we have the infamous or heroic Mario Gonzalez. Mr. Gonzalez filed bankruptcy in the early 90s, and a notice for a sale of his property was in a newspaper in 1998, and it kept coming up on Google search results. And so he went to the Spanish Data Protection Agency, which is the AEPD, along with about 100 other people who the agency declared had a right to invoke some type of objection to the processing of their data. This got appealed. Mr. Gonzalez's case, as well as 5 others, got appealed through the Spanish court system, and the Spanish court system kicked it up to the European Court of Justice, the highest court for the European Union, to get some clarity on this issue. The case that came out of this was the one that was handed down in May of 2014 that freaked everybody out, and we'll talk a lot more about it. But this is Chris Pertz. He was an honor student and a football player at Berkeley in 2006 when he got into some trouble at a strip club. And the Daily Cal covered it, and he ended up getting kicked off the team. And his life took a downward spiral from there, and he actually died in 2010. And in his obituaries, the links to his name pulled up these old accounts of him at this strip club, and his parents were really, really distraught. Of course, they had just lost a child, but they were distraught about how his obituaries were being presented, and they begged the publishers to remove this content to the old information. They actually ended up suing the publishers for intentional infliction of emotional distress and lost for 2 main reasons. The first is that the claims were too old. So because the publication had happened so long ago, even though the harm was this accrual of pain, the statute of limitations had been violated, and they could not pursue their claim. There was also a problem with pursuing a claim like this that would essentially edit news content based on the emotional distress of a parent. We also have characters that are more or less sympathetic. We have Wolfgang Werl and Manfred, who I often call Alfred, Lauber. These are the 2 guys who tried to get Wikipedia to take off their reference to the murder of a famous actor. So there was a lot of outcry when they had tried to do this, but if you look at it from a German perspective, it doesn't actually seem that crazy. What happened was they were convicted of murder against their claims of innocence of a very famous actor in 1993, and when they were released in 2007 and 2008, they sought to have their names removed from websites that associated them in relation to their crimes. And a number of German websites complied with this because of the German constitutional rights to personality and informational self-determination. A number of lower courts had held that online archives were the same as a current dissemination, which was a violation of these rights for people who had been convicted of their crimes. But when it got appealed to the Federal Court of Justice in Germany, the court they developed a two-part test. The first asks whether the content is actively pushed out to users, whether it's linking to it or referencing back to it, or you have to actively search and archive for it. And the second part of the test is whether the content appeared new to the user or whether it appeared to be part of an archive. So this is not Lorraine Martin. This is Jim Morrison, because I cannot find Lorraine Martin's mugshot, her Connecticut mugshot, but this is Jim Morrison's Connecticut mugshot. Sort of interesting that I can't find her mugshot. I've gotten very good at finding mugshots on the internet. But Lorraine was arrested in 2010 along with her sons, and the local news agencies covered this, and she was never prosecuted, and the arrest was nulled under Connecticut's erasure statute. And what that means is that all of the government records for her arrest had to be destroyed, and she can deny being ever arrested. So she is given this legal truth that she was never arrested, and with that, she sued these websites that continued to allow access to those original arrest reports for libel, saying that it was a lie. And this case went up to the Second Circuit, and they just heard it a few weeks ago, and basically said that while Lorraine Martin is given this truth, it doesn't make those reports any less true. They can't be punished, these news sites can't be punished for publishing what is also true. So what we see emerge out of this is extreme polarization on this subject. And anybody who's kind of looked into this, you can tell that there are some extreme views on each side of the Atlantic. And this is, of course, in large part due to the fact that we have very distinct legal cultures within Europe and in comparison to the US. We have a bunch of shared values that have different labels and different definitions. The emphasis on dignity in Europe includes these personality rights that mean something slightly different in a number of European countries. For instance, in Germany, the informational self-determination drives a lot of their jurisprudence and regulatory frameworks. The withdrawal of consent is something that the French really hold on to. We're seeing more and more development of what it means to have your identity controlled in a big data environment. And what is of public interest is highly scrutinized. Well, it's more highly scrutinized than it is in the US, and it's done so in different ways across these different institutions. In the US, of course, we have speech top and center. Under that, reputation and privacy. This is, of course, not always true, so in a general way. But one of the most interesting things is that for informational claims, there is a doctrine that informational claims are not provided injunctive relief. So I am paid when my reputation is hurt. So providing injunctive relief is seen as a prior restraint on speech and gets a lot of constitutional scrutiny. So saying, hey, you have to take down this Facebook post because it's defamatory and you can't post it again, or because it's an invasion of privacy, is not really something that the US courts do doctrinally. We're seeing a little bit more of it at the lower court levels across the US, but they haven't really been challenged. I think it'll be a really interesting aspect of the next decade in US law. But another very important difference is the institutional structures between the two regions. In the US, if we wanted a right to be forgotten, we would have to get legislative movement. And without that, we would have to see it developed in the courts, which just takes a really long time. And one of the Supreme Court justices actually said when he was talking to a high school, he sort of brought up this question that, do Americans have this right to be forgotten? It's sort of suggested that, hey, maybe we do. We don't necessarily, it's not necessarily true that we do for sure do not have it. Whereas in Europe, these things can start at the Data Protection Agency, and as long as they meet these standards set forth by the European Union and the Council of Europe, they can move through and develop a little bit more quickly. But where we see the most interesting and the most impactful differences is in treatment of intermediaries, which is why the case with Mario Gonzalez was so interesting, because we really saw the distinctions between treatment of intermediaries play out. And I think Americans were quite shocked at how this could play out. Everyone, I think, was quite shocked. So if you go to Google and you say, I want to take something off the internet, you get this little drop down, and it's, I think, got 5 bullets. And the first asks if it's a European claim, and then another one asks, if it's illicit material like child pornography or something. So you kind of work your way through this. But for similar claims, you would get these 2 different slides. This is the takedown removal slide for Google that it developed after the case was heard in 2014, in May of 2014. So you put your name in, where you're from, and you ask for these links to be removed because the information is inadequate, irrelevant, or one of these other very seemingly exotic words for Americans. If you are American, it sends you to this site where it says, here's how you can send this request directly to the webmaster of whoever you're trying to deal with. So it basically says, we're willing to remove content with a court order for specific types of material like your social security number, things like that. But for the most part, you either need to go directly to the site or you need to sue the site directly and then bring your victory, your piece of paper that says you're a winner, to Google, and they will remove it. One thing that's really interesting is that under US law, they don't even have to do that. Under Section 230, which has been expansively interpreted, Google really doesn't have to do anything. Even if you say, yeah, this was a horrible violation of my privacy, the court even said so, you still go directly to the source to have it removed. And as we just talked about, removing content through US law can be really, really challenging. So another reason that we have this extreme polarization is due to some conceptual problems with the right to be forgotten itself. It is very save history or save humanity, save these individuals from the tyranny of Google, or save the historical integrity of the internet, both which have major problems, of course. But I use this chart to break down what the right to be forgotten could actually apply to, using Twitter as an example. And what we see is there's actually a lot of nuance here. There's sort of like an a la carte menu. What we have is internal data, internal information, which is information that I create about myself. So I have data that is passively created as I move through this space, and how long I linger on a link or what I click on, who I'm connected to, creates a certain amount of data that here I just have generically listed as click streams. So on Twitter, this would be, as I'm moving around from page to page and scrolling over things and opening pictures, I'm leaving this data trail that Twitter collects, and as it resides with Twitter, it is internal data residing with the initial site. And when Twitter sells that data, it moves downstream. I also have content that I create myself. So I have the tweets that I post. This is actively created information. It can reside with Twitter, but it can also be bumped off of that and moved into somebody's Twitter stream on a website or something. That is a whole set of this has a whole set of issues in and of itself. There's also stuff that other people create about us that can be really problematic, of course. So I'll do the content side first. So external content is things that people actively write about you on Twitter. So anyone that tweets something that has me or my picture in it or anything like that. And that, of course, can be retweeted or it can move off the site entirely. I used to have these two as not applicable, that people could not create data about you. But over the last year, I have decided that's not true. And I call this inferred data. And what we're seeing so much of, I would say in the last 2 or 3 years, is that companies are filling in gaps for us. So I'm sure most people in the room know about the target pregnancy collection. So this is the kind of data that is created. If I go to Target and I buy all the things on the pregnancy list, Target infers that I am pregnant. So I don't create that, somebody else sort of creates that about me. So using a chart like this, we can see extremes by mapping on the European and our little baby US effort to achieve digital redemption. The data protection regulation is set to replace the 1995 directive. So the difference between a directive and a regulation in Europe is that under the European Union, the directive says, okay, all European Union countries, here are your guidelines. You have to put certain things in place. So the 95 directive told all of the member countries to put data protection agencies in place. So that's why they all have them. And to put certain protections in place using whatever national system was the most appropriate for them. The regulation will harmonize all of these, is an attempt at least to harmonize all of these. And if you look at it, we have Article 17, Part 1, which looks very much like the directive. It says everyone has a right to object to processing, that there has to be a legitimate purpose for the processing, that you can't process, that you have a right to erase and rectify certain information. And this all sounds like cookies until you look at Part 2, where it specifically gives procedures for this content when it's been made public. So if we look at Article 17, it very much could apply to all of these. And there's not a whole lot of guidance on how to apply it to all of these. It has a number of exceptions, but they are things like speech and history and research. So really how the exceptions are applied will make or break the right to be forgotten. But with the court case on the 95 directive, I think that we're going to see a pretty expansive take on what the right to be forgotten means under Article 17. And I should mention that in the amendments to the regulation as it's going through the lawmaking process in Europe, they changed the title of it to the right to erasure. They didn't change anything else really about it. But in the US, for the most part, none of these are really available legally. But I will mention the California privacy law that just went into effect in January. We jokingly call it CLOPA. It's just for kids, but it's kids under 18, so COPA applies for kids under 13. CALOPA is for kids under, I'm sorry, COPA applies to kids under 13. CALOPA applies to kids under 18, and it only applies to this box. So it only applies to California kids who are under 18 and have done something really stupid online. And you have to have a user account. So it's that kind of environment. It has to be a place where you sign up. They have some sense of who you are. And as soon as it moves downstream, everything else is untouchable. So it's just this box right here. So one of the other problems related to the right to be forgotten and this extreme polarization is that it has been framed in a very dramatic way. And I can't get my video to pull up, but it is good enough that we pulled it up on YouTube. So this is a PSA that runs on the Disney Channel from Phineas and Ferb. So I hope you all can hear it. I think you'll be able to.
Hey, Phineas, what you doing? Hey, Isabella. You know how a lot of kids go online, right? Well, to help keep them safe, Ferb and I decided to laser inscribe on a meteor our very own cyberspace rules of the road.
Mom, Phineas and Ferb are making a public service announcement.
Be careful what you put online. It never goes away. Ever. Name is fleeting, but the internet is forever. And you never know who's gonna see it.
There's no way I'm letting this baby out of my sight.
Hello, children. I'll take that.
And just because it's online.
So that is what kids see numerous times a day if they watch the Disney Channel. And this is a screenshot of Amanda Todd, who killed herself at age 15. She's a Canadian teenager who was a victim of cyberbullying in the what is now tragically stereotypical. She sent out a somewhat scandalous picture and then was bullied relentlessly. She had to drop out of school. And 30 days before she killed herself, she put this haunting video on YouTube that recounted her story. And there's no words to it. It's just these cards that she's handwritten. And this is about 3 minutes in, she puts up this card that says, "I can never get that photo back." So permanence, digital permanence, is not only polarizing, it's also really, really dangerous. And it's also not very true. It's not very accurate. So digital data is incredibly fragile. A lot of things have to go right for you to get a piece of content from one server to another. The web was not built to preserve itself. The average website still lasts about 100 days. This was an old stat from the Internet Archive, and has apparently remained, for the most part, static. A number of reasons, of course, contribute to this. Everything from natural disasters to upgrading sites. But for simplicity purposes and for the right to be forgotten purposes, what we see is that a lack of interest and a lack of money leads to lots of things falling off of the web. This is, of course, called link rot. I'm sure you guys have, you see 404 errors all the time as you move through the web. We also have digit rot. We have a number of things that contribute to digital information not remaining discoverable. And there's actually a room in the basement of the University of Colorado that was my favorite room when I was there getting my Ph.D. And it's walls of old computers, so that if you wanted to study an old piece of software, for instance, or an old video game, you had to go find some piece of equipment that could read it. And so they had this whole big room in the basement that would allow you to do that. One of the most interesting things about digital ephemerality is that .gov sites have the highest decay rates. So we're losing .gov content more than we're losing anything else. And a recent study done at the Berkman Center found that over half of the links in Supreme Court cases are now dead. So we are losing a lot of important information, and we're holding on to a lot of information that is causing harm. The point is not that anything is or is not important, but that we have no systematic approach to what I call information stewardship. Most of our communication and privacy laws developed over a really, really long time for paper records, books, newspapers, diaries, filing cabinets. It's a very sophisticated system. And this is an example of paper ephemera. You could just call it ephemera since we don't have anything. It only applies to paper. But ephemera is a category of information like birthday cards and event posters and to-do lists and receipts, things like that that used to be enjoyable for some amount of time, but were really destined for the trash. And we had this medium, we had this mechanism to do this kind of thing. It was, of course, it's always existed. It's developed into kind of these clear categories. And this is actually a shot from a collection at the Bodleian Library of ephemera. And what we don't have now is digital ephemera. And I think that that points to how young the web is, but also the right to be forgotten can be understood as an attempt to define categories of ephemera. And it's not necessarily bad that it does so, but that it is taking an extreme approach and not an information stewardship approach that really takes into account the nuance that exists in this information landscape. So part of this sense-making that comes with assigning, socially speaking, what do we think is ephemeral digital data? What do we think is really historical or has some other significance? Requires us to have an understanding of the pulse of any country or any culture. And this was a poll taken by Software Advice just after the case came down in May 2014, and it asked Americans their opinion on the right to remove irrelevant information from search. So irrelevant information isn't something that Americans are used to being exposed to. It's not part of our legal discourse. We know what the word means, of course, but we don't know what it means in terms of removing content or legally removing content. And so we have this big 21% of people saying that it's too hard to define relevancy. We have 40% saying, we don't really care how you define it. Yes, everyone should have this right to remove irrelevant information. But before we open this up into a larger conversation, I would love to know how many people in the audience think that there should be no right to be forgotten, whether it's data, content, anything. There should be no right to be forgotten. How many people think that you should have a right to delete your passively created data? So data that's collected by a platform. More people, yeah, okay, pretty close up, I would say 70%. How many people think that you should have a right to obstruct access to or delete or some set of circumstances to reach that content category? To see it, yeah, so search engines. So you could edit Google search results. You can ask those to be deleted. A few iffy people. So that one has a big, that one has a.
It'd be nice to have. I don't know if it's a right, but.
Yes. So I think the only way Google's going to do it is if it's a right. But this is my last slide. I would love to open it up to have a larger conversation about this. Thank you very much.